Welcome, everyone. I'm Mike Nichols with the Piper M-Class Owners and Pilots Association. Thrilled to be moderating this evening a joint webinar between PMOPA and the Cirrus Owners and Pilots Association. So I'd like to welcome both groups, and in the registration, we asked you to tell us which group you were a part of, and I was excited to see that a number of folks are members of both associations. We are joined this evening with Scott Williams. He is our presenter. Scott is an FAA licensed commercial pilot with multi-engine and instrument ratings and has over 3,000 flight hours. He just finished a 14-state trip across the country and back, so lots of current and recent experience flying his Cirrus SR-22T. Scott's a frequent presenter at EAA AirVenture, other aviation organizations. He's been a longtime Cirrus owner, first with an SR-20, now the 22. And he's both a member of the Cirrus Owners and Pilots Association, where he's a past president, and a member of PMOPA. If you have questions throughout Scott's presentation, I'm going to ask that you type them into the Q&A portal. If you're on your computer, you should see that in the bottom center of the screen. Just click on that, type it in, and at the end of Scott's presentation, we'll have plenty of time to go through Q&A. Excited to have you here, Scott. Thank you very much for taking time. Looking forward to your presentation this evening, and I'd like to thank all the attendees for joining us. And with that, I'll turn it over to you, Scott.
Okay, thank you, Mike, and everyone, good afternoon or good evening, whatever time zone you may be in. I woke up this morning with the ultimate aviation dilemma. I'm a member of COPA, I'm a member of PO, and what shirt am I going to wear today? I decided on neutrality. I'm wearing my Oshkosh shirt. We're just going to go with that, and this way nobody gets offended. So with that in mind, let's move into our presentation, FAA Investigations or Works, Ramp Checks all the way to Enforcement. I've been privileged to give this presentation once before this year for another group. They didn't throw tomatoes, so we're going to give it here today. And as Mike said, we'll take Q&A after the presentation. With any presentation involving a lawyer, as you probably know, we have to do a few legal disclaimers. You already knew this, but this presentation does not constitute or create an attorney-client relationship. If you want to engage in a relationship, it has to be offline. Reminder, this is being recorded, so there's definitely no attorney-client privilege of any kind. Always consult with your own individual legal or tax advisors, as the case may be. Our focus today is on operations of U.S. aircraft and pilot operations in the United States as regulated by the FAA. If you're from Canada or other countries, we're all global, we're all pilots, but most of what I'm going to cover may not apply to you because this is specifically for U.S. Federal Aviation Administration relations. We are not giving advice today on how to deal with law enforcement. If you are ever contacted by a law enforcement officer, you need a criminal defense attorney, even if you are innocent. So please don't say, well, I saw Scott Williams' presentation and he told me, Sheriff, that you can go pound sand. Not a good idea. I'm not going to tell you what to do if you're arrested. Obviously, you should remain silent and always seek defense counsel. And if your airplane gets impounded, that may be outside the scope of this presentation. More likely than not, it's not the FAA that's impounding your plane. It's either a taxing authority or a law enforcement organization. So having said what this is not about, we're also not going to cover medical certificate issues outside the scope of my practice. We're going to talk about pilot certificate operations rather than medical certificates. So with that in mind, let's go right into the ramp check. Many of us in this room have already been ramp checked, and if you haven't been ramp checked, your day may come. What do you do if you get a ramp check? What is it, and what's the FAA looking for? First of all, let's clarify what the FAA cannot do in a ramp check. They cannot arrest you. They can refer potential criminal activity to a law enforcement agency, but the FAA, the FSDO inspectors, and everybody else who works for the FAA does not have any powers of arrest or detainment. They can look bad, they can look onerous, but they can't arrest you. They can't ground you or your aircraft, and this is something that unfortunately a lot of even FSDO inspectors don't understand exceeds their authority. They cannot tell you that you're unable to fly an airplane. They can strongly recommend that they think your aircraft is unairworthy. They can strongly recommend that they think you may not be qualified to fly that plane today. And if you do fly that plane in violation of their recommendations, you're probably going to be in an enforcement action. However, they might be wrong and they don't have the authority to tell you you can't fly. The FAA cannot demand that you answer their questions. They can ask you some questions about documents, and we'll talk about those in a minute. But the FAA is not permitted to use a ramp check as an interrogation or an interrogatory or any other legal proceeding. Having said that, if you're asked relatively innocuous questions by the FAA, this is probably not a good time for you as a pilot to say, well, I know my rights. I don't have to answer your questions. That's not going to set a very good tone with that relationship. Keep in the back of your mind, most RAM checks are random in nature. It is merely the FAA doing their job, trying to keep honest people honest, and it's their way of making sure they keep the sky safe. Most VSDO inspectors are good people, so don't view this as a hostile relationship if it doesn't need to be. The FAA cannot board your aircraft, and rarely will they make a demand to board your aircraft, but they will often say, hey, do you mind if I step on board and check out your really cool avionics? It is your decision whether or not you want them to board your aircraft. If you have a Cirrus SR series, well, you can simply open the door and say, there's my avionics. You're welcome to stick your head inside for 30 seconds and look. If you're flying a Vision Jet or a PA-46, where you actually have to go in, you have the right to say no to the FAA's request to board your aircraft. If you want to grant them access, you can. Just be clear that if you are going to grant somebody access to board your aircraft, that you find out why they're going in there and that you limit their scope and duration to something very reasonable. The FAA can also not unreasonably delay your departure. A RAM check doesn't have to be done in 90 seconds, but it shouldn't take an hour either. There is nothing wrong with you saying to the FAA, I respect what you do. I know you've got a job keeping us safe, but I've got a window, a slot reservation. I've got a flow to a particular airport, and I don't want to lose my flow. So let's move on, please. And if you give a good reason, they usually will respect that. So in a RAM check, the FAA does have the right to inspect certain aspect of the aircraft, and specifically, they're going to look for these things. Number one is they do have a right to say ask for your airworthiness certificate. If you don't have one, your plane is not airworthy. And yes, it does have to be an original. A photocopy is not legal, although I've written articles on how a copy is better than nothing at all. You do have to have a registration and you have to have a pilot's operating handbook. Just to clarify, the registration has to be current. If your registration is expired, your aircraft is unairworthy. The pilot's operating handbook is supposed to be the paper handbook with all the proper documentation, weight and balance, and everything else. I will tell you that the FAA, for a Part 91 operation, generally won't object to your POH being on the iPad, so long as it is a full and complete POH with all the scan pages that are specific to your airplane, meaning just downloading a POH from the manufacturer's website is not a full POH, and it's not good enough. A weight and balance. Now, they have a right to see, do you have a weight and balance on the airplane, but that's not the same as a weight and balance calculation. You're not required to produce the weight and balance calculations for a particular flight. You need only say that you did it and you're good to go. If you are using aeronautical charts, they have a right to ask what charts you're using. And also, if you do use charts, they have to be current in nature. They can't be outdated. They also can check your ELT battery and VOR checks. Oh yeah, what's a VOR check? It's the ones we used to log and don't have to log, but we still do have to log them. It's the navigation updates we don't have to log anymore. You're supposed to log and have a record of VOR checks. ELT battery inspections, no different. Okay, so let's take a look at what the document, what the FAA may inspect as to the pilot as opposed to the aircraft. They absolutely can ask to see your pilot certificate. And I want to clarify, see or inspect is not the same as possess. Never, ever, ever hand your pilot certificate to a FSDO inspector. You hold up your pilot certificate so that the FAA inspector can see it, and you offer to show them both sides, but you never hand the certificate over. It could, under the wrong circumstances, be considered a surrender. The FAA knows that. They tried that garbage with Bob Hoover many years ago, which was one of the many reasons why we have today a pilot's bill of rights. They also have a right to see your medical certificate and to make sure that they will ask you what type of operation are you conducting. If you only have a class 3 and you're out there doing commercial operations, you should expect you're going to have a problem. So your medical certificate must match the type of operation. You do have to have a photo ID. Photo ID has been required for many years, along with your pilot certificate. Could be a driver's license, could be a passport. As of right now, the FAA has not said anything about requiring a real ID, as in the same type of real ID that you need to board an airliner, but you do have to have some kind of a photo ID issued by a governmental agency. A photo ID from a private organization doesn't count. They also have a right to inspect the pilot's logbooks only if your pilot logbook is required to be on board, and that's generally student pilots. Uh, Never, as a pilot, ever, ever, ever fly with your logbook, not on paper. And if the FSDO inspector says, hey, can I inspect your logbooks for your recent IPCs and BFRs? Your response is going to politely be, I have that at home, happy to provide it for you. Never fly with your logbooks, either your pilot logbooks or the aircraft logbooks. So assuming all goes well with the ramp check, you're going to get out of there pretty quickly. 99% of all ramp checks really end with, thanks, have a nice day, everything's fine. These FAA inspectors are really not looking to cause problems unless they sense something is wrong. If the FAA really thinks that something nefarious is going on, they could call their supervisor. They may ask you to visit their FSDO office. And in a worst case scenario, they could say, hey, I'm going to call law enforcement. If those things happen, by all means, think about what you should say or not say. But lawyering up at the mere sight of a ramp check is generally not going to help you. It's only going to make things more confrontational than they need to be. So let's say the FAA wants to actually investigate wrongdoing. This is not a random ramp check. This is something more serious. How does an FAA investigation start is the first question people ask. And they basically start with, hey, you've got a possible pilot deviation. When you land, call this number. That's also known as a Brasher warning. I'm often asked the question, what do you do when the FAA controller says, here's the phone number? Well, first of all, you do copy the number down. And in the old days, we used to tell pilots, absolutely, positively, don't call, have your lawyer call. Things have changed a lot. We'll talk a little later in this presentation about how most cases are going to the compliance program. And right now, all I can say is that when you do get that number, it's not a bad idea to make the call and be a good listener. They also may get a public complaint about something that happened regarding your aircraft. There may be an incident or an accident that gets reported to them by the tower, by somebody else. It could be an anonymous tip. Recently, I had a client investigated for running an unlawful charter operation with the Mustang when somebody who was on the field thought that they were holding an aircraft out for charter without a certificate, and they did an investigation. So, as to enforcement matters, the Pilot's Bill of Rights that got enacted in 2012 really gave pilots somewhat of a level playing field with regard to FAA enforcement actions, and we'll talk about some of those protections. First of all, if you are now being investigated for potentially wrongdoing, if the FAA even senses that they're going to maybe pursue a violation, they're supposed to give you a letter of investigation and a separate Pilot's Bill of Rights notice, also known as the PBR notice. Doesn't have to be on paper, could be by email, but it can't be verbal. They actually have to tell you what they're investigating and that you have rights under the PBR. Much like the Miranda rights we have, you have the right to remain silent. They are supposed to timely notice all enforcement actions and appeals process. In other words, if they send you a notice of proposed certificate action, they have to tell you what the process is. If they actually decide to bring the certificate action, they have to tell you what your appeal rights are with an NTSB administrative law judge. And they now have to give you much better access to the air traffic control data. There are websites you can go on. There are emails you can send to request data to make sure that you have access to what they have access to, because sometimes the data is very much in the pilot's favor. In all NTSB administrative law judge hearings, they're no longer loosey-goosey like in the old days. They're now bound by what's called the Federal Rules of Civil Procedure. And that means that other than the specific procedures that are unique to NTSB administrative law judge hearings, all these hearings now follow federal rules of evidence, federal rules of civil procedure. Pilots are getting a much better fair shake in these hearings than they used to. Also, the administrative law judge is not bound by the FAA's interpretation of a statute. The FAA will claim that they can interpret their own regulations, but that's not always holding water. So the good news is the administrative law judge can look at a statute, look at a regulation, make an independent decision as to what that actually says, and not be bound by the FAA's version of what they think, how they think things are working. Then the good news is we had a second Pilot's Bill of Rights 2 that became inactive and effective in 2016. This further expanded your rights as a pilot. It now expands the Pilot's Bill of Rights to all mechanics. Our firm actually does a lot of work defending certificated A&P mechanics, and now those same rights apply to them in those hearings. The big news is that now the FAA has to bring an enforcement action against the pilot within 2 years of an investigation. So the minute the FAA knows or should have known that a potential violation occurred or that their investigation was leaning towards some type of a violation finding, they actually have to bring the enforcement action. And that means not just the notice of certificate action, but now they actually have to bring the complaint. So this means that they've got to get inside the NTSB's judicial system within 2 years. And we'll talk about a case that made this very, very important. It also limits what we call fishing additions by aviation safety inspectors. The FAA has broad investigatory powers to investigate safety matters, but they can't just ask for documents and data and logbooks without a good reason to do so. So if the FAA inspector woke up one morning and said, "Hey, I want to randomly pick any pilot out of a list and demand I see their logbooks," they're not supposed to do that. They're supposed to have some kind of a reason to ask a pilot or an aircraft owner for their logbooks. And certainly any incident or accident is usually a good reason, but they can only look for things that are relevant to that incident. They're not supposed to go back through 10 years of logbooks. The FAA now must also provide the releasable portions of what's called the EIR Enforcement Investigative Report. And I say the word releasable because much of these EIRs are still blacked out and redacted if they contain opinionated statements of a particular inspector or if they contain communications between enforcement counsel and an aviation safety inspector. Having said that, don't be surprised when you first get an EIR that you've requested that there's a whole bunch of black redactions. And then sometimes we have to push for, hey, you've over redacted this, kind of like the Nixon tapes, and let's maybe pare these redactions down to give us more of a fair analysis. And I've often got the FAA to give us more content and less redactions the second time around. So people often ask me the question, how much of your practice is transactional and how much is FAA enforcement work? Well, before 2015, it was about 50-50. Anybody want to take a wild guess what it is right now? Guess what? It's about 90-10. 90% transactional and only 10% FAA enforcement. Thank goodness to what's called the compliance program. This started out as the compliance philosophy. It's now embodied in a program, and it defers most matters involving FAA violations to counseling or remedial training. Not all, but most. In order to qualify for the compliance program, the safety inspector, and more importantly, their manager, needs to make a determination that the violation was not willful or deliberate. They also look for people that don't engage in multiple violations or that they're walking violations every year something comes up. Those people may go to enforcement. But for the most part, most of the violations that we used to see automatic 30-day suspensions on, like Bravo bus, TFR bus, um, not calling a tower within, 2 miles of the radius of the airport. Those used to go to enforcement. Fortunately, they're all going to the compliance program. The compliance program, though, is not eligible in cases involving falsification or lack of qualifications. So, for example, if you let your BFR lapse by a day and you went out and flew, they might put you through counseling, but more likely than not, they're going to say, hey, you should have had tracked this better, and now you're no longer eligible. If the FAA thinks that you falsified any document of any kind in any matter, they're not going to put this through compliance. So the compliance program is designed for, oops, I made an honest mistake. It's not designed for people that willfully violate the regulations. The key to the compliance program is not only getting into it, it's also staying in it. In order to be in the compliance program, the FAA wants to see that you have a serious commitment to safety, that you're willing to listen, and that you'll cooperate with any counseling or training that the FAA offers to provide. If your attitude is, yeah, I'll go through the motions, but I don't believe in anything you're saying, and I think I'm a safe pilot and you're an idiot, you should expect to call me for enforcement defense because they're not going to keep you in a compliance program if that's the direction your attitude is going. In the old days, we used to fight everything. Before 2015, the smallest violations were going to enforcement. Pilots were getting 30-day suspensions for the stupidest stuff. And at some point, the FAA realized that's not good. So how does this affect what we do as pilots? We need to have a little bit more of a, I really appreciate it, and I apologize for the inconvenience. Whereas we'd never apologize for anything before the compliance program. So if the matter is not ripe for compliance and it actually has to go through a more formal enforcement process, here's how it works. It commences with a letter of enforcement, a letter of investigation. And if the FSDO or the FSDO manager determines it does not fit squarely within the compliance program, it'll take the alternate path, which is usually the FAA's Enforcement Counsel's Office. They start with a notice of a proposed certificate action. And in that proposed certificate action, they have to list out specifically the violations that they think incurred that warrant some kind of an enforcement. They have to give the facts and the code section that of the FARs that they think you violated. The key is here, there's what's called a stale complaint rule. And the stale complaint rule says that from the date the FAA knew or should have known about a violation, they have to get you this notice of proposed certificate action within 6 months. If they're longer than 6 months, the pilot has an equitable defense of latches and can move to have the complaint dismissed. If you get a notice of a proposed certificate action, also known as a certificate enforcement action, all is not lost. The FAA will still often negotiate a settlement, either for a reduced suspension, maybe sometimes a 709 ride, or in many cases, a lesser suspension or a lesser penalty than they're seeking in their notice. If you're this far along in the process, this is no longer being nice to the FAA. You need a lawyer the minute you get a proposed certificate action. If they cannot settle the matter with the pilot, if the pilot does not agree to stipulate to whatever penalty is in the proposed certificate action, or something lower that's negotiated, at that point, the FAA will issue what's called a complaint. And a complaint is basically a retype of the notice of proposed certificate action. And this is the one that we have to respond to formally with an appeal to the NTSB's administrative law judges. This is a different arm of the NTSB than the accident safety investigations you see on television that investigate railway and airline accidents. So what happens if my case gets to the point where I have a complaint? What are my options? What are my rights? And how's the process work? So you, the airman, must file an appeal within 20 days of receiving service of the complaint, and you must file it with the proper form with the NTSB's office. The good news is, in the old days, they wanted everything in triplicate. Now you can file electronically. It's pretty straightforward and not complex, but you really can't and shouldn't be doing this on your own. You're going to need legal counsel to get this far. If the FAA has determined that your matter is an emergency case, we'll talk about that in a minute, you no longer have 20 days, you have 10 days to respond to an emergency complaint. So make sure you know these deadlines and get counsel right away. The good news is, if it's a regular case and it's not an emergency case, you get to keep flying, or the mechanic gets to keep wrenching all throughout the process. You do not have to stop flying or surrender your certificates in a regular case. In an emergency case, you must surrender your certificates, and if you don't do so, you'll incur serious civil penalties on a daily basis for every day those certificates have not been turned in to the FAA. They'll give you a couple of days grace period, but if they think something is so serious as to warrant an emergency case, you must, absolutely must surrender, and at that point, you've got to stop flying. Well, I shouldn't say stop flying. Stop exercising the privileges of your certificate. If you want to go up with a buddy and your buddy is licensed and certificated and has a medical and says, here, you take the controls. Well, we do that with non-pilots every day, and you can be one of those non-pilots. You just can't exercise the privileges of a surrendered certificate. If the FAA determines that this case is so serious that it warrants an emergency designation, this is the strictest timeline on the book. You, the pilot or mechanic, have a mere 2 days to challenge the FAA's designation that the case warrants being an emergency. That doesn't give you hardly any time. And sad to say that 95% of all of the challenges to the FAA's emergency designations are denied. What happens here is the NTSB's chief judge hears these emergency determinations, and all they're looking for is this violation so serious that you flying a plane right now could be a threat to safety? And did the FAA take this action as soon as reasonably possible after they conducted their investigation? If those answers are yes, the FAA's emergency designation is going to be upheld. So rarely do these designations get challenged or overturned. If you get an emergency designation, you are entitled to a hearing in less than 30 days. Why? Because you no longer have a certificate. It's been surrendered. The FAA, under the Pilot's Bill of Rights, can't drag this out, so you get a hearing within 30 days. Sometimes your legal counsel will say, hey, we need more than 30 days to prepare a defense. Let's waive the emergency hearing deadline, and now you're going to be back in the regular queue. The queue for a regular enforcement case is somewhere between 3 to 5 months, depending upon what part of the country you're in and what the NTSB's administrative law judge's vacation schedule is, but they're running about 3 to 5 months, give or take, for regular cases. All right, so in 2025, we pilots, finally got a really big case in our favor. It was the FAA versus Trebi, and the docket number is SC 31332 if you want to look it up. I told you earlier that the FAA is required under the Pilot's Bill of Rights to bring the actual enforcement action within 2 years of the date that they kind of knew something wasn't right. So this case derived from a Part 135 charter pilot that allegedly flew too fast down low near the CRQ Carlsbad Airport, Palomar. And that was the basis of the allegation. The investigation started with a noise complaint by a resident. Go figure that. They don't like low-flying aircraft. The FSDO had already suspected that there was a violation before they called the airman in this case. So they've already got a low-flying aircraft complaint. They knew, or they should have known, that this is likely going to be a violation, assuming that this low-flying aircraft did occur. So the order 8900.1 directs the FAA to give a pilot's Bill of Rights notice before contacting the airman. It could either be before or like simultaneous with, but you can't contact the airman and start asking questions in an investigatory manner if you think a violation has occurred before you give them the pilot's Bill of Rights. This is akin to our Miranda warnings. If you fail to give a Miranda warning to a suspect and the suspect confesses before the Miranda warning is given, the confession is out the window, as called inadmissible. So that's kind of what the FAA is facing here. So this case was all about, hey, you didn't give this particular pilot their PBR notification. On that basis alone, we're going to dismiss your case. Ha ha ha. But wait, there's more. The FAA didn't serve the order of suspension for 3 years after the letter of investigation was first created. Well, if you read back on the Pilot's Bill of Rights 2, the deadline is 2 years. So the court also held that because they were over 2 years, that also results on independent grounds for dismissal. So they basically dismissed this case twice in the same ruling on 2 different independent grounds. Now, there is an exception for the 2-year rule under Section 805 of the Pilot's Bill of Rights 2. Senior leadership at the FAA may extend the 2-year period for good cause, but that's just not the local FSDO office. It has to be pretty high up the food chain, and somebody has to have a documentation that they did more than just make a phone call. We're looking for an email from something like the administrator, a deputy administrator. Yes, this case warrants an extension. Otherwise, on that basis, this case was dismissed. I know you've got lots of legal questions, both the ones that are typed so far as the ones that are coming. So what questions do you have? I'll stop my screen sharing and let Mike read the questions.
Right. Very informative, Scott, as always. Thank you so much for that very thorough, detailed review of the processes and what we should be prepared for as pilots if the FAA should come knocking. So just as a reminder for folks, if you have a question, please type it into the Q&A portal and I will read the questions to Scott and he'll have an opportunity to provide some thoughtful answers. So first one is, does the paper POH need to be within the pilot's reach in flight?
So the pilot's operating handbook needs to be in reach. Whether it's the paper or the iPad version, there's a lot of discussion as to whether the iPad version is acceptable. My personal opinion is for a Part 91 flight, provided that your iPad version has all of the required documentation, including the scan pages that are specific to that aircraft, I think that's good enough, and I don't think the FAA can win an enforcement case to the contrary. Having said that, I'm only using my iPad as an absolute backup if some mechanic tossed my POH in the trash can and I'm out of town. So yes, it needs to be in reach. Reach can be behind the seat, but it shouldn't be in the baggage area.
All right, very helpful. Thank you. Next question is, what should be provided for ELT battery inspection?
Wow, I have to look that one up again because it's been a long time. I'll defer that question to my going back and reading the regs again. But the ELT has to have both a battery inspection as well as the tested annual, and I think it has to be documented in the aircraft logbooks. But I'm going to defer that question to. Let me go back and read that again.
Okay, great. And we can respond offline to the person who
Sure.
asked the question. We'll have a record of that. Next question. Many of us now fly with electronic logbooks, such as the ones that are generated by ForeFlight. What is a reasonable response in this case if the FAA, during a ramp check, asks to see the pilot's logbook?
So even though you've got automatic logging in ForeFlight or some other mechanism, I still would give the response to the FAA. My logbooks are at home. I'll get them to you in a reasonable time. How would you like them? And then we go from there. Um, I still keep the old-fashioned Excel spreadsheet logbook, and that's my favorite way of doing things. Do I cross-reference FlightAware? Do I cross-reference ForeFlight and Garment Pilot? Sure. Uh, but the problem with just giving the FAA safety inspector immediate access to your ForeFlight logbook, you have not had a chance to look that over. You don't know if all of your IPCs and your currency flights were properly logged. And if you missed something, and if you were current, but you merely didn't log it properly, this is your chance to fix it. I don't ever advocate that you ever give the FAA any false information. Never falsify a logbook, not a maintenance logbook, not a pilot logbook. But hey, just look it over carefully to make sure you're current before you send this stuff over.
Perfect. Thank you. Next question. This participant just had their first call this number. The result was that they made them take a wings course on pilot deviations and just closed the case. It's not a question, more of a comment. The individual says that they were very nice and very professional, and it's a new pilot. So this individual was sweating bullets, but they thought that the FAA was very good about it. So it's nice
Very
to hear
common.
compliance philosophy is working.
Yeah, I'll disclose to the group that I got my first brasher warning in about, gosh, almost 10 years. I took off out of Torrance, and normally I'm calling SoCal right away because I'm climbing high and fast. It was a low ceiling day. I stayed along the coastline at 2,000 feet, which, not thinking, I put myself into Long Beach's tower airspace. Basically, I called the wrong controller. So I'm talking to SoCal. I should have called tower. Tower said possible pilot deviation. As I'm talking to the FSDO inspector, he's like, yeah, I get it. This happens all the time. Let's just have a chat. Here's some material for you to read. Have a nice day. I mean, this stuff just doesn't go anywhere.
That's great. If it's something intentional, the result could be a little bit different, but
Right.
mistakes, there's generally positive attitude. All right. Next one up is, with basic med paperwork, pilots need to keep that documentation with the logbook, but you say they shouldn't carry the logbook. So how best to keep the basic med paperwork in the event that they're ramp inspected?
So our office does not handle medical matters, but I generally, while you do have to carry a medical certificate on you, you I have to go back and check. I don't believe you need to carry. I would never carry my unless you're a student pilot. If you're a student pilot, then all bets are off. You have to carry your logbook with you. But your basic med certification, the questions typed, we need to keep with logbook. I don't believe that's accurate. Your basic med paperwork and your pilot logbook are independent documents. So I'll get back to you on that one.
Okay, thank you. Next one up is, what do you do about VOR checks on electronic cockpits? Should a log be in the aircraft somewhere?
So many of us have self-authenticating VORs and identifying checks and like I believe the NXI system, which is also known as Cirrus Perspective Plus. I believe it's pretty good about pretty much doing the VOR check for you. So I don't think you need to log a VOR check for some advanced avionics systems, but if you have old-fashioned steam gauges like this, you do, and there's obviously the checks of either doing an air check or a ground check or a cross check. But there's no requirement to carry those VOR checks in the aircraft. They just have to be somewhere.
Thank you. Next question is also a VOR question. I've been told that the VOR check is not required in all cases. That now sounds wrong. Can you?
Yeah, same answer. I think some avionics are now self-authenticating. Don't really track it carefully, but I think for many modern avionics systems, the VOR check is done by the avionics system itself, but nonetheless, it's never a bad idea to have it.
Right. This attendee read somewhere to not show weight and balance and logbook documents to a ramp check, but to say that they're at home. However, if they have the logbook or weight and balance with them, that would be a lie. Is it willful, as you cited before, so it would make this person non-eligible for the compliance program?
So I want to clarify the difference between the weight and balance of the aircraft as opposed to the weight and balance calculations for a particular flight. The weight and balance for the aircraft, the empty weight and balance, has to be provided to make sure that there is one. With regard to your weight and balance calculations, if you have them on you and you know for certain that they're accurate and that they show you within the appropriate weight and balance for your aircraft, I've never said that you're wrong to provide those to the FAA inspector. Just make certain that what you're providing is right, because often I've heard cases of, I did a weight and balance on these circumstances, and the FAA inspector says, yeah, but you got one more passenger here. And now your weight and balance isn't accurate anymore. I always like taking the opportunity to say, look, I did a weight and balance calculation at my house. I'm happy to give it to you. The fact that you also might have a more rudimentary or backup weight and balance calculation on your iPad does not compel you to turn it over, and that would not disqualify you from the compliance program.
Great, thank you. With respect to enforcement actions, when does a pilot's 20 or 10 days to appeal begin to run? Is that upon the FAA's mailing it or the pilot's receipt of the mail?
Upon the FAA's mailing it, your date of receipt is irrelevant. And the number one reason why those deadlines get blown is pilots and aircraft owners don't keep an accurate mailing address on file with the FAA. I've been pushing for years that the FAA should have an email address for all pilots, like they have for all aircraft owners. And they should be obligated to email these notices for people who are on vacation and don't check their mail but every 2 weeks or whatever. The FAA's position is, if you're out of town for 2 weeks, someone should monitor your mailbox. I think that's harsh. I think that's unfair. But hey, that's the FAA. That's not me.
Next question, can you comment on the voluntary reporting of violations? Is it a good idea or not?
So the term voluntary reporting can go one of two ways. If you're talking about, would I voluntarily report a violation to the FAA, the answer is no. But without getting too drawn out in NASA reports, you should be filing a NASA report for any incident, and your deadline to do so is 10 days from the date you knew or should have known that a violation occurred. It doesn't mean the penalty won't be brought against you, or the action won't be brought against you, but it'll stay the penalty in cases unless it was deliberate or willful.
Thank you. Just a reminder, if you have questions, please type into the Q&A portal. We have one, not question, but a comment. One of the instructors in the PMOPA community says a current VOR check is only required if you are IFR and using the VOR system for navigation, citing Federal Aviation Regulation 91.171. So
Right.
thank you.
And so most of us are flying GPS aircraft and we're flying RNAV approaches. You wouldn't need to have a VOR check for that approach. The only problem is if the FAA ever, raises the minimums of that RNAV approach to where it's substantially above the ILS approach, and you need the ILS for minimums, you might be into a VOR situation. So just be aware that yes, a lot of us don't fly ILSs anymore because we don't need to, but someday you might need to.
All right, Scott, we have no more open questions. So we'll just hang a minute because in my experience, some folks have trouble finding where to type the question or the question comes towards the end of the webinar. So we'll just wait kind of for a couple seconds and see if anything else comes in.
Nobody has said horrible presentation. I'd like at least maybe one person to say I kind of enjoyed it, but that's okay.
I'm sure you'll.
All right, there he is. Fine, thank you.
Thank you, Adam. Good job. Another one great PowerPoint. What a great audience, great presentation. This is a lot of fun to do this jointly with the members of COPA along with the PMOPA members. So Scott, thanks for being active, engaged in both organizations, and appreciate your willingness to take time and share your expertise to keep us all out of trouble. So thanks everyone for participating. Have a great evening. Take care. Bye.